The following administrative directions already exist for presiding judges and registrars of high courts where trials on indictment are to be held to assist in speedy and effective trials. Please ensure that under no circumstances is any juror placed on the list of more than one court, thereby eliminating the possibility of any juror being involved in cases pending in more than one court. Trials are to be conducted from day to day, all day, such that the courts in the criminal sessions will be able to determine one case from start to finish within a few days before beginning the hearing of another. Judges are respectfully required to comply strictly with the practice direction Effective Case Completion Planning Strategies of 2019 found in the 2017-2020 1 SCGLR 422 and the practice direction on jury trials which came into effect in May 2024. Since disclosure is mandatory by the decision of the Supreme Court in Eugene Bafuboni versus the Republic, 2017-2021 SCGLR 327, and the timing of disclosure has been held to be important in determining whether or not adequate facilities have been afforded the accused person to be able to put up a defense. It is expected that the prosecution will be directed to file full disclosures in the cases before the jury is empaneled in order to avoid delays by keeping jurors on hand without actually doing any work. The timeous filing of full disclosures would even inform accused persons or their lawyers of the opportunity to take advantage of plea bargaining. Because of the direction that disclosures be filed in full before cases are listed, jurors should not be summoned or empaneled until disclosures are completed. The practice direction Effective Case Completion Planning Strategies 2019 directs that a case completion plan be prepared at case management conference before the commencement of the trial. It also directs that trial period be fixed. It is my hope that courts will meticulously walk through this process to ensure the efficiency hoped for. Courts may also, in offenses not punishable by life sentences but triable on indictment, such as rape, direct that the trial be undertaken by the presiding judge with the aid of assessors instead of with a jury. In that case, the judge would have the choice of selecting not less than 3 assessors, which would require fewer number of people to assist in trials. Since the qualifications of jurors and assessors are the same, assessors can be drawn from the same pool. Warrants may also need to be issued to other justices of the superior courts who may not ordinarily be engaged in criminal sessions, but whose schedules and specializations permit to sit anywhere in the country from day to day, all day, within a specific number of days in some of the cases, so that we will be able to achieve the completion of an appreciable number of cases within this session. At the end of the day, judges are respectfully asked to effectively manage cases for speedy resolution of cases. Judges are also requested to ensure strict compliance with sections 222 to 224 of the Criminal Procedure and Other Offences Act 1960, Act 30, which provide for consequences for non-attendance to court by a juror. Further to the above, if a juror who has been empaneled fails to attend court on a day, it will be understood that no work was done, thereby affecting the ability to pay allowances for the day. In this regard, 4 men are respectfully requested to notify all jurors on a panel regarding attendances well ahead of the days of the court sitting. Accused persons on bail are also to ensure that they are present. In default of this, there may be consequences for trial in absentia in accordance with law. Judges are respectfully requested to ensure strict compliance with the Legal Profession Professional Conduct and Etiquette Rules 2020, LI 2423, when it comes to the conduct of lawyers representing various sides of the criminal justice system, such as private legal practitioners, prosecutors, lawyers at the Public Defender's Division of the Legal Aid Authority, etc. As we know, police and prison officers play crucial roles in facilitating trials by producing accused persons and evidence in a timely manner. The Judicial Service of Ghana therefore respectfully requests that they take adequate steps to protect trials from delays. Witnesses are essential for the trial process, with the prosecution and defense responsible for their timely appearance. I request all judges to use available judicial orders to track and compel the attendance of witnesses for the avoidance of delay.